Thank you, sir. Anchors, please start. स्टार्ट करेंगे। शुरू तो बोलो।
Anchors, kindly start the meeting.
हाँ, प्लीज स्टार्ट नाउ। शुभांगी, प्लीज स्टार्ट।
फोन सब लोग वैसे ही रखते हैं। फोन
हो जाएगी।
कैमरा वो माइक ओपन है आपका।
Anchors, you can unmute yourself.
Good morning, respected guests. There's a technical glitch. We're trying to solve it at our end. Sir,
Good morning, sir. Shall we begin?
Yes, please.
Yeah, please go ahead.
Justice is a constant and perpetual wish to render everyone his dues. Law is not an instrument of oppression, nor a tool for the powerful, but the guardian of the weak and the voice of unheard. It stands as a shield of liberty and the sword of truth, ensuring that fairness prevails even when the odds are uneven. A very good morning to everybody present over here. Myself, Muskan Singh Sikka, and today with my co-host Bhumika Mishra on behalf of the organizing committee, I take great pleasure in greeting you all and extending a cordial welcome to this event dedicated to knowledge, learning, and justice. Today, we are gathered here for the inaugural session of Trial Advocacy, where the courtrooms comes alive not in reality but in learning. Ladies and gentlemen, today we step into the shoes of an advocate, of judges, and of witness, not only to argue a case, but to experience the spirit of justice itself. So, before we proceed with today's inaugural session, let me just acknowledge the very fact that we are extremely delighted by the gracious presence of Professor Dr. V.C. Vivekanandan sir, Honorable Pro Chancellor sir, Senior Vice President RBEF, Lieutenant General V.K. Sharma sir, Ati Vishisht Seva Medal, Honorable Vice Chancellor sir, Professor Dr. R.S. Tomar sir, Professor Dr. M.P. Kaushik sir, Honorable Pro Vice Chancellor, all the registrars, deans, directors, all the HODs and HOI, all the reverted faculty members, and our dearest participants. Every good work begins with the grace of divine power. So, to make the divine beginning of today's event, we humbly request and start our event with the blessing of Goddess Saraswati. A remarkable academician is one who not only imparts knowledge but also instills value, inspires students to think beyond the book. A true leader is one who leads by example, guided with vision and humanity and unwavering dedication. And together, these qualities create a personality who shape mind, build character, and leave an everlasting impact on everyone they touch. Professor Dr. R.S. Tomar sir, MSc, MPhil, PhD, FRSB London, FCBEES Hong Kong, FICER, FSLSC, FIASC, has served as Vice Chancellor of IES University, Bhopal. Prior to the IES University, he was the Director and Head of MAT Institute of Biotechnology, Dean of Life Sciences, Dean of Academics at MAT University, Madhya Pradesh, Gwalior. He was the founding campus head of MAT University, Gwalior. Professor Tomar has more than 32 years of teaching, research, and administrative experience in the higher education in varied disciplines of science, including the life sciences. Professor Tomar is actively engaged in teaching, research, and innovation. His research interests include the nanobiotechnology, microbiology, herbal medicine, cancer biology, animal biology, environmental biotechnology, and he has to his credit more than 150 research papers published in various national and international journals of repute. He has filed 25 patents, of which 22 have been published, and 2 patents have been granted, and 4 are under the process for grant. Professor Tomar sir has published more than 5 books and 35 book chapters, and which are published by the national and international publishers. Recently, a book entitled The Nanobiotechnology, Concept and Application in Agriculture and Environment, edited by him with co-editors, has been published by the Apple Academic Press, CRC Press, USA. He has delivered lectures in more than 60 national and international seminars, symposiums, conferences, and workshops, and he is a member of various national and international scientific bodies and a reviewer and editor of national and international journals. Recently, he has been elected as a fellow member of Indian Academy of Sciences, Allahabad, India. So we now request our Honorable Vice Chancellor, Sir, Professor Dr. R.S. Tomar, Sir, to kindly enlighten us with your words of wisdom. Please, sir.
Thank you, dear student. Good morning, everyone. The chief guest of this national level competition, Professor Dr. V.C. Vivekanandan, Honorable Vice Chancellor, Hidayatullah National Law University, Raipur, Pro Chancellor Lieutenant V.K. Sharma, Aviation retired, Pro VC Research, Professor Dr. M.P. Kaushik, organizer of this national level competition, Major General Rajendra Kumar, the HOI of ALS, Deans, HOI, HODs, and participants. It's been immense pride and honor that I welcome you all to this trial advocacy competition being organized today by the MIT Law School. That is a celebration of intellect, advocacy, and the pursuit of justice. Today marks the more than just the beginning of a contact. It marks the continuation of a journey where law students transform into future lawyers, not by memorizing statutes, but by living the courtroom experience. It's first time we are organizing this competition. We all know that in ancient India, the Nyaya was one of the 6 classical schools of philosophy, a rationalist system that is founded by the sage Gautam or Gautama around 2nd century BC. Its name, or what you can say, Nyaya, means right, justice, or method. And the system is essentially the science of right judgment, true reasoning, or logic. That is also called as Tark Shastra. पुराने समय में इसको तर्क शास्त्र बोलते थे, The primary aim of Nyaya is to achieve liberation. That is, moch is not that moch which people get after death. I'm talking about any kind of justice by which people feel liberated from suffering, which is believed to arise from ignorance or by acquiring true knowledge through methodological reasoning and a framework of 4 valid means of acquiring knowledge. That is, first is perception, means pratyaksh; inference means anuman; comparison, upaman; and verbal testimony, that is shabd, in which a judgment is given. The words are more important than anything else in the judiciary. Advocacy as such is defined as an action that speaks in favor of, recommends, argues from a cause, supports or defends, or pleads on behalf of others. Advocacy includes activities and publications to influence the public policy, laws, and budgets by using facts, their relationships, the media, and messaging to educate government officials and the public at large. Mock trials, we keep on doing that. We organize various kinds of moot court competitions also. So mock trial is a method of critical legal education which is provided to the budding lawyers. Learning the law in practice at the college level is the essential part of a mock trial. A mock trial is nothing but a model court trial offered through simulation. It teaches the students of law in practice before the criminal court. Any criminal case before the real court takes years together to complete the procedure, including judgment. But in mock trials, students are trained to show the complete procedure within a span of 1 hour. Mock trials are not mere simulations. They are the training grounds where legal minds sharpen their reasoning, refine their oratory, and learn the art of persuasion. Here, every objection raised and every argument delivered is a rehearsal for the real-world challenges that lie ahead. It is the arena that students learn to think critically, speak confidently, and uphold the values that define our legal system. In short, mock trials are not just academic exercises, they are transformative experiences that build the mindset, skill set, and confidence of future lawyers. I would like to highlight some of the importance of these kinds of competitions. So this is trial advocacy competition that represents a dynamic experiential learning opportunity where students stimulate courtroom proceedings from opening statements and witness examinations to closing arguments. These competitions provide a real-time experience to the students of law profession. This event is more than just a competition. It's a vital step in shaping the next generation of legal minds, equipping you with the robust advocacy, drafting, and logical skilling lead that are needed to excel in this dynamic profession. I would like to highlight some of the duties of a good advocate. Any advocate's duty include upholding their client's interest through fair means, which actually somewhere disappearing nowadays. Maintaining the dignity and respect of the court, ensuring full and frank disclosure to clients, and acting with honesty and professionalism to help administer justice. Advocate must also respect the court's rules by appearing in proper dress, not influencing judges privately, and not suppressing evidences that could prove a client's innocence. I would like to say to all participants that this competition is not only a test of your knowledge of the law, but also of your ability to think critically, argue ethically, and respond with composure. Each argument you make today is a step in honing these skills that will define you as future leaders of the legal profession. This is your movement. Embrace it with passion, precision, and integrity. A lawyer's duty is not only to his client, but also to the court and to the cause of justice. Let that be your guiding light today. I extend my best wishes to all participants. May this competition be an enriching learning experience marked by spirited debate, respect for differing viewpoints, and a commitment to truth and fairness. I also appreciate the efforts of organizers, mentors, and volunteers who have worked tirelessly to make this event possible. With great anticipation and admiration for the talent gathered here, I now declare the mock trial competition officially open. Let the arguments begin and may justice prevail. Once again, best of luck to all participants. Thank you very much. Jai Hind, Jai Bharat.
Thank you so much, sir. Honor is not a matter of any man's calling name, but rather of his own actions in it. Now, I take the privilege of introducing you to our perennial beacon, the illuminating fountainhead of visionary ideas, Lieutenant General V.K. Sharma. General V.K. Sharma joined the prestigious National Defense Academy and passed out as a permanent commissioned army officer from the Indian Military Academy on 31st of March 1972. He was granted the President's Commission in the Corps of Signal of the Indian Army, served the Indian Army for almost 40 years, and retired from the second highest rank of Lieutenant General, which is a 3-star and a flag rank of the Army. During his meritorious service, he held several command and staff appointments and participated in Operation Rakshak and Operation Vijay. He also served for almost 7 years in the Jammu and Kashmir Valley in Srinagar in the ranks of captain, colonel, and brigadier. General Sharma has also been an excellent academician in addition to being a military leader. He has had the unique distinction of standing first in BE, ME, and MMS programs. He has also been an instructor at the Institute of Armament Technology, Girinagar, Pune, which has now been redesignated as Defense Institute of Armament Technology. He has also been the commandant of Military College of Telecommunication Engineering, located at Mau, MP, for a period of 3 years. During service in the army, he has traveled to almost every nook and corner of the country and has also headed military delegations to France, Germany, and USA. For his meritorious service to the nation, he was also awarded the Ati Vishish Seva Medal by the Honorable President of India on 26th of January 2011. He has also held the appointment of Colonel Commandant of the Corps of Signals for a period of almost 4 years. Lieutenant General V.K. Sharma is the founder Vice-Chancellor of MIT University, Madhya Pradesh, Gwalior. He is presently the Pro-Chancellor of MIT University, Madhya Pradesh, Gwalior, and has seen the exponential growth and has been adjusted amongst the best private universities in Madhya Pradesh twice by CMAI and NIRF. Most recently, the university has been ranked the best private university in Madhya Pradesh and amongst the top 25 private universities in India by India Today in 2021. He has also been instrumental in introducing a host of best practices aimed at fostering academic excellence in the university. We now request our Honorable Pro-Chancellor, Sir Lieutenant General V.K. Sharma, Ati Vishish Seva Medal, to kindly enlighten us with his words of wisdom. Please, sir.
Thank you very much for the introduction. Professor Dr. V.C. Vivekanandan, the Honorable Vice Chancellor of Hidayatullah National Law University, Raipur. Professor Dr. R.S. Tomar, the Honorable Vice Chancellor of MIT University, Madhya Pradesh. Professor Dr. M.P. Kaushik, the Pro Vice Chancellor and Dean Research, MIT University, Madhya Pradesh. Major General Rajendra Kumar, Ati Vishish Seva Medal and Sena Medal. The Director of MIT Law School. All the faculty members of MIT Law School, all the HOIs, HODs who joined the conference today, and all the participants who will be participating starting today and ending with the competition on 20th of September. This is the first of its kind trial advocacy competition 2025 that we have organized at our university. Earlier, we have been organizing the moot court competition every year, but this one we thought that the students must be given an experience to see how the lower courts, the trial courts, or the subordinate courts of the judiciary, they function. And very happy to say that we have about 30 teams participating from all across the country. Each team having 5 members, and all of them will be given time, and we will be conducting the presentations online, preliminary and quarterfinals, and the final presentations of semi-finals and the finals will be conducted offline in physical mode at our university on 19th and 20th of September, in which 8 teams are likely to participate. The aim of the trial court is to ensure the development of various skills in the participants. And in today's environment, the skills which are required, I think, are changing than the requirements in yesteryears. Today, we require ethics in judiciary. Today, we need integrity in judiciary more than ever before. We also need to speed up the trials, considering the number of cases that are pending, and not ask for adjournments or give adjournments at the drop of a hat. We require sharp minds. We require good communication skills, not only communication skills, listening skills as well. The judges, the lawyers should have excellent listening skills. They should also have an eye for detail. They should be able to find out where there are loopholes and should be able to say in a limited amount of words and limited time what they wish to say on those loopholes, get to the witnesses, get to the root cause of what has happened, and be able to deliver a judgment which is acceptable, which is wise, full of wisdom. Here I am reminded of a character called Daniel, and when in the Shakespeare's works in Merchant of Venus, when the judgment required a pound of flesh to be taken from a person who had not repaid the loan, and the judge was to give that decision, he said, okay, you can take the pound of flesh, but make sure not a single drop of blood falls. And then it was said that a Daniel is come to the judgment. That still stays as a proverb. That kind of judgment we require today, which is clean and which still serves the purpose. The purpose of judiciary and the punishments given is to make a society crime-free, to have a society which can reform the criminals rather than sending them into jail aimlessly or for longer durations. Today, even the highest punishment which is given for death sentence, even that is under scrutiny. And there are many countries which are abolishing the death sentence or bringing it down to jail in the courts. The cases which are pending are far too many, and that is something which the students need to learn and find out and advocate the alternative sources, routes of judgment, which includes mediation to a large extent. And I'm happy to state here that we have a mediation cell in our university functioning under the approval of the state legislative authority of Madhya Pradesh, and we have successfully resolved a number of cases through our mediation cell. Students must get trained on mediation because, in my opinion, mediation is the way forward to move on to reduce pendency and the obvious advantages mediation offers to speed up the court cases, to get the judgment in the desired manner, at low cost, in a speedy manner, and therefore, in all contracts which are signed, we need to incorporate the sentence that mediation shall be resorted to whenever there is a dispute, so that the cases are speeded up and the justice is delivered in time. Remember the famous saying, justice delayed is justice denied. There have been cases which are more than 50 years old, which are still pending in the courts. The students today, the teams which are participating, I'm sure in the mock trial, it will enable them to compress the judiciary process, to demonstrate the entire process in a structured, time-bound framework. And this fast-paced yet rigorous exercise develops not only the tactical skills such as effective courtroom communication and sharp witness handling, but also strategic thinking, where participants learn to guide the flow of the trial towards the intended outcome. With this, I wish the participants all the very best and great success for this first trial advocacy competition 2025, and wish all the participants all the very best, and may the best teams win, and may the best memorial advocate and researcher and best witness get the prizes that they fully deserve. So thank you very much. Best wishes. Jai Hind, Jai Bharat.
Thank you, sir. Now, it gives me immense pleasure and honor to extend a warm welcome to our esteemed chief guest, Professor Dr. V.C. Vivekanandan, Honorable Vice Chancellor of Hidayatullah National Law University of Raipur, Chhattisgarh. We are truly privileged to have with us Professor Dr. V.C. Vivekanandan, who has 3 decades of teaching and research experience in legal education and served NLS Bangalore and Nalsar Hyderabad between 1990 to 2017. He was the dean at Rajiv Gandhi National School of IP Law at IIT Kharagpur between 2009 to 2010 and was the founding dean of the School of Law at Bennett University at Greater Noida during 2017 to 2019. He holds a bachelor's degree, master's degree, and PhD degree in law, apart from a master's and MPhil degree in public administration. Professor Vivekanandan was appointed as the MHRD Chair Professor in 2008-2009 and again from 2010 to 2017. During this tenure, he was also representing Government of India negotiations in SCCR meets at Geneva as an official delegate from 2013 to 2015. He was an elected member at the at-large committee representing Asia Pacific region, participating in the deliberations of the Internet Corporation of Assigned Names and Numbers between 2008 to 2010, and later became a member of the nomination committee of ICANN between 2010 to 2012. He was the founding director of the Legal Information Institute of India during 2010 to 2012 as a part of the Free Access to Law movement. He also served as the NWO ICCR Fellow at Maastricht University School of Law and as invited scholar at the Institute of Intellectual Property at Tokyo in 2010 and 2015. He is also an adjunct visiting professor of Sunny Buffalo Business School since 2007 for their programs. Professor Vivekanandan specializes in teaching, research, and advocacy of the fields of intellectual property law and internet law. He also established the Nalsar Proximate Education at Nalsar University and headed the division between 2001 to 2009 and 2010 to 2017, which offered PG diploma programs of patents, cyber law, media law, and international humanitarian law. The division also ran a master's program in tax and business law for the probationers of the National Academy of Direct Taxes, Nagpur, during 2008 to 2016. He serves as jury with CII on the selection of IP awards since 2015, and also served as a jury with Firmexil for IP awards in 2013 to 2015. He has key publications in national and international journals, has contributed to book chapters in international publications. He is also an invited speaker in reputed institutes in India and abroad. His non-law interests include music, cinema, and travel. Now I would like to request our esteemed chief guest to kindly enlighten us with this valuable insights. Please, sir.
I hope I'm audible to all of you. Am I audible to all of you?
Yes, sir.
Yes, sir, you are audible.
Thank you.
Yes, sir. Yes, sir.
Thank you. Thank you. So, Lieutenant General V.K. Sharma ji, Honorable Pro-Chancellor of Amity University, Madhya Pradesh, and Senior Vice President of RBEF, Professor Dr. S. Tomar, Honorable Vice Chancellor, Amity University of Madhya Pradesh, Major General Rajendra Kumar, Director ALS, organizers of this trial advocacy competition, faculty and students of Amity University, other aspiring law students of other institutions participating in this competition. It is indeed a pleasure and a privilege to be invited for this important event and would like to thank the organizers for doing so. The American jurist, Judge Learned Hand, way back in 1944, in a speech in the spirit of liberty, said the following statement: liberty lies in the hearts of men and women. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. It's a very profound statement about how humans try to organize themselves over a period of time. In our evolution as Homo sapiens, as social animals, we try to organize ourselves for a peaceful life. And such peaceful life is not something, a picture perfect thing. Obviously, you have a lot of issues, violence, many things which have shaped our history. But in such journey, we have very, very carefully nurtured a plant called liberty. And so what happens is, when we try to live peacefully and there are differences happening, naturally law comes into place. As you said that only one person living in an island don't need a law. Two persons living in an island, sooner or later will develop some difference, right? And there has to be a resolution which has to be brought. Imagine today a world of 7 billion plus. So naturally we are talking about our aim and ideal to lead a good civic life. But the point of criminal laws, which I'm supposed to touch upon today in my inaugural talk, has been also evolving over a period of time. And in fact, I would rather say it got stunted in Indian context for a very long time. Till 1 year before, if I asked any student about which is the criminal law which you are implementing, they will talk about 1872, 1860.
You got muted.
Sir, you've been muted. Sir, kindly unmute yourself.
Dr. Vivekanand ji, please.
Sir, you are not
unmute yourself.
audible.
Please unmute.
Okay.
Yeah.
Is it audible now?
Yes, sir.
Yeah,
Yes,
yeah.
sir.
Okay. It got I think
Last-
muted
last
somewhere
few
in between.
sentences- Sir,
So
last-
what I was trying to put across is,
last few sentences
for a
of
very
your
long
speech I could not
period,
hear.
we have been using laws which were drafted and implemented at a point of time where this space and people were not even free. So in such case, for a very long time, we have been talking, but nothing happened. And finally, the new criminal laws came into force. And obviously, in the world of law, for everything there will be a critique. For many people did critique that this is too early. This is too fast. This was not deliberated well, etc. But I need to remind very interestingly another incident when Henry Ford, whom is considered as the father of automobile industry in the world or in America, when he said in early 1900, when he said that I'm going to give one car to every American, people laughed at him and said, there are pretty bad roads in America, cobblestone roads, no tar road, and you're talking about an expensive gadget at that time called as automobile to every American. What kind of foolishness? But Henry Ford answered differently. He said, good roads will come only after good cars come. It is not good roads will come first and then good cars will be produced. Since you have a good car, you will demand for a good road. So many a times what happens is, if you are going to wait and wait and wait for a long time, I don't think so anything is going to happen. Maybe wait another century. So probably we had this new criminal laws coming in, which has its own issues, which has its own critiques. Put together, the laws were rolled about a year back. If I do touch upon that as an important aspect for your competition, I think by now 1 year has rolled past. I think even the first year law student is familiar with the three new nomenclatures. One is the Bharatiya Nyaya Sanhita, which is nothing but substituting the Indian Penal Code. And the second one is the Bharatiya Nagrik Suraksha Sanhita, which is replacing the Code of Criminal Procedure or CRPC. And the third one, the Bharatiya Sakshya Adhiniyam, which really supplants the Evidence Act. So I'm pretty sure that in your school and every day you are now doing criminal law in your classes. You are very much means getting into the nitty gritty. But let me try to put in my talk one perspective. As I said, there are a lot of perspectives when it comes to a subject of law, right? Or there is no one story to be told. There are multiple stories always, and in fact, such multiple stories enrich the dialogue. Such multiple stories enrich the fabric of democracy and better working of law. So if I look at few of the headlines which are shifted now, thanks to this rollout of the three new laws, I would like to point out few things. Number one, the whole concept of sedition is out, but sovereignty offense is in. Or in other words, section 124A IPC sedition is not carried over, whereas BNS 152 penalizes acts endangering the sovereignty, unity, and integrity of India. The sedition discourse was more under the British rule of a colonial rule. But we are talking about a more positive aspect of sovereign, we the people of India. So, but obviously, the underlying factor is same. In sedition, it was rebelling against the colonial master, the sedition was there. But in sovereignty, it's a hard-earned, hard-fought independence. So one needs to defend it, and so they have taken a new type of narrative on sovereignty. It is covering speech, science, electronic communication, and financing of secession or armed rebellion. So this scope and safeguards are being watched closely is one shift which can infer in the new criminal laws. If we go to the next one is there are new offenses. The government official explainer of the Home Ministry flags addition for terrorist acts, something called mob lynching, snatching, and organized and petty organized crime. And so mob lynching has been a kind of thing which unfortunately post-independence era, much recent days, we are really watching. Then people used to call democracy and mobocracy. That was there from the time of Socrates and Aristotle. Democracy is about an organized way of a majority coming or a method of voting, and then the others accepting it, until some changeover happens. But mobocracy is very, very dangerous in the sense that nobody knows what each one wants, but everybody takes in law into their hands. So that is one of the new things which this new regime is going to do, which means it is going to reflect the contemporary harm patterns which were not there earlier. And so these are new offenses, which is a second, I would call it a kind of a headline shift from the old laws to the new laws. Third one is community service. The BNS explicitly lists community service as a punishment option for select minor offenses. A move to decongest prisons and also to tailor proportional sanctions. Right? This is now official. I do remember long back in Chennai, High Court, I'm talking 2 decades back, that for a particular offense, the judge ordered the person who was talking through his act on certain comments and kind of defamation, he ordered this person to stay 1 month in the Gandhi library in Madurai. Every day he has to go to the library, sit 1 month, and at the end of the day, like all your law students are giving a project assignment, he said after a month, you will tell what you understood about Gandhi. He did not want to preach Gandhi in a courtroom. He said, you go there, stay 1 month, probably you'll have a change of heart. This is one of the way of a community service. In a very, very interesting fashion, he said. But these are all selective judges were telling selective ways. But today it has been, I call it the headline shift of getting official, which means there's a lot of minor. And I don't know about Amity, university in HNLU. Now this is part of the proctoral rule. It is part of the proctoral rule for many minor offences. There will be a community service. You may wonder what is the community service. Maybe you have to attend all the seminars, sit and take notes. Right? So this is one way of trying to make people learn as well as be useful instead of hurting people. So the next one, technical shift I would say, is the preliminary inquiry under BNSS 173. This codifies preliminary inquiry before registering an FIR in a narrow band of cases where the punishment is less than 3 years and 7 years, a 14-day limit, which is an attempt to reconcile the Lalit Kumari case of FIR mandate with practical screening. This was being brought into the new law. And then the next one comes of the under-trial detention cap, which is under 479, which caps pre-trial incarceration relative to the maximum sentence. Many a times, the final offense would have landed you in 3 years, but you would have spent as an under trial more than 3 years, which is very common in India when we see for the past, because they don't know who is going to, build the cat, and it is just left like that. And suddenly you see somebody coming out of the prison almost 2 decades later for an offense which is very less. So they've done a capping now, and the Supreme Court has applied this provision expansively in few cases, which I will try to touch if I get the time in few minutes. Then the digital procedure, EFIR summons, AV recorded statements, and remote testimony. States are building up the pipes, what we call forensics, video links, mobile labs. And again, the same question. When this came, many people were really critiquing, is the police stations having budget, or is many of the law enforcing people had, how can all these things come? As I said, you get my point. Many a times at home, you don't prepare an elaborate dinner and then invite people to the table. You invite people and the cooking happens parallelly. So obviously there is a law and a necessity. Probably budgets will happen. Probably things will be procured. So it is not such a major thing. But you can see that in the 1 year run up, we do a massive training program to the Chhattisgarh Police Department, and we were getting very positive reports how many of the law enforcing things are equipped with this. Then also what you call as the last one, I would call it as electronic evidence, which is elevated as digital records as a primary evidence. It clarifies authenticity, chain of custody pathways in a tech neutral fashion. That's very important because again, technology has its own problems. Because end of the day, what is the technology? It's a code. And who writes the code, the way they write the code, could many a time decide outcomes. So now the clamor is for something which is tech neutral, what they call, which cannot be having an inbuilt bias. So these are some of the things I would highlight. Since what you call as I'm almost nearing my time in one way, I would like to little bit put a critical analysis for few minutes, before I wind up my address to you. Number one, which I said, sedition to sovereignty. It is the critique is clarity versus overbreadth. Replacing sedition of one with BNS 152 definitely was decolonizing the code while safeguarding national security. The text sweeps in acts done, quote unquote, purposely or knowingly, that excite or attempt or excite secession or armed rebellion. Critics are little worried about the vagueness, about purposeful. Purposeful, how you will be really interpreting, and in what context it will be interpreted. Will it be selectively interpreted? And what kind of chilling effect it will have? And also, mens rea proof under digital age speech. In digital age speech, is it very clear? Can we come to a mens rea? These are problems. So, the constitutional scrutiny on precision, proportionality, and necessity tests under the Constitution, Article 14, 19, and 21 assumes great importance, and many of you witnessed in the last 1 year, many of these are now coming to the Supreme Court and they are trying to rework or analyze how this is being handled. The second one I said, organized crime is the new harms, which I said is, it is a specific response based on data-driven policing and sentencing calibration. The upside is there is a clear visibility and consistency. But on the downside is the overlap with existing homicide, robbery provisions, risking charge or stacking, they call it, and even invocation across states. And so, what kind of standard operating procedure, what kind of training on these things with the enforcement officials, and what kind of charge framing to be done becomes an important issue. The next one, which I said, community service and penal rationality, I mentioned. The critics, where they are looking at, will it have a kind of a global restorative trends, or it will be reduced to an overuse? And most importantly, what is the monitoring compliance of this community service? I say do community service, but how do you do that? Really monitor whether it has achieved its purpose, and this requires much more analysis and how to make it happen. And the next one, which I said, is timeliness of preliminary inquiry. This aims to curb mechanical FIRs and reduce frivolous criminalization. But at the same time, we have to really have the risk that a preliminary inquiry morphs into what they call a threshold barrier for genuine victims. The Supreme Court has already started drawing guardrails in few of the cases in the last 1 year. And also, under trial incarceration, it is finally a hard break. The problem is, how do we really do the mid-trial, multiple FIRs if they are filed, and if there are fragmented jail records, how do we manage? So it is a most welcome move, but at the same time, we need to take care of these kind of risk issues. And as the last two which I touched upon, digitalization and e-process, the issue still is, apart from simple mobile and WhatsApp itself is not a digital word. It itself is not a digital word. Even though we are in multiple languages, even the very ordinary person who is not having formal education is managing. But the whole digital way of putting few things requires certain level of understanding and sophistication. Will people be blamed for not understanding this, and then will they get into more problem, is something which you have to wait with some level of empirical research will reveal what needs to be done to make the promise of digitization and e-process vis-a-vis the kind of capacity what we have in terms of handling this. And also, as I said, lastly, is I said, what is the constitutional review on the horizon? So you find many courts from Supreme Court in recently asked the Madras High Court to prioritize hearing of such challenges rather than taking them up immediately, to expect a record to be built. So these are some of the things, and if any one of you, all the people who are doing this, I'm pretty sure in a competition, they have done the homework about what even happened in the last 1 year in the rollout of this will be there. And 1 year is a very small sample for 3 major laws in a country, size of the country and the size of issues what we are dealing. But I'm pretty sure that it will give us some kind of hint about to move quickly rather than post-mortem after few years, how to do this. So the point which I want to again reiterate is our own jurist, a world icon, Justice Krishna Iyer, whose quote is often quoted everywhere, that bail is the rule, jail is the exception. And this is, whether you call it the old criminal laws or new criminal laws, when you talk about liberty, that is the case. As often they say that 10 criminals can escape for lack of evidence, but one innocent should not be punished is one of the bottom line or foundation of open societies. So what we need to really look is how police and prosecution, how they are going to really work is to be watched, and how bar, what I mean lawyers, how they are going to really contribute to expand this jurisprudence, to expand the nuances of the new criminal laws. And finally, very importantly, the guardian of justice in a way is the judiciary, and they need to really very carefully calibrate this, and all put together. All this starts with law schools, that is law academia, because we have a greater energy, greater creativity, greater insight, greater way of analyzing things. And in that context, I would say that your trial advocacy competition is in towards such right direction, and the organizers as well as the heads of this institution, bringing this important event is definitely a very important milestone, not just of exposing to students, but contributing towards trial advocacy, especially with these 3 new laws. So with this particular closing thing, I would say that the new codes has given India a very modern toolkit. Their success will depend upon how tools are used by the police, by the prosecutors, by the judges, and how law students are going to really, what you call as, bring in new light along with the teachers, the academicians. So thank you very much for giving me this interesting opportunity to interact. I do hope to interact in future with the university. I understand Amity is all over the country. Even we know that we interact a lot with the Amity at Raipur in Chhattisgarh. They do come for our programs, and we some of us go to their programs. I look forward to a continued association. So let me thank Professor Thomas for inviting me, and also thank Lieutenant General as well as Major General, for having me with you. Thank you.
Thank you so much, sir, for your valuable words of wisdom. A true academic leader is one who enlightened the minds with knowledge and inspired the hearts with value, with vision, with dedication, and with humanity. They nurtured the future generation and leave a legacy of wisdom and guidance. Major General Rajendra Kumar Sir, Ati Vishisht Seva Medal, Sena Medal, Vishisht Seva Medal, and alumni of prestigious ILS Law College Pune and University of Pune. Sir got commissioned in the Department of Judge Advocate General of Indian Army, which is its judicial wing. During his services in the Indian Army, he had conducted numerous court conducts, including those of sensitive nature, and he has represented the Indian Army in the Supreme Court and various high courts of India as well. While serving in Jammu and Kashmir, including the Leh and Ladakh and northeastern states, he also took part in various military operations like Operation Rakshak, Operation Parakram, Operation Orchard, Operation Javelin. And for rendering these distinguished services, beyond the call of duty, he has been awarded thrice by the Excellencies, the President of India, conferring him with Ati Vishisht Seva Medal on 26th of January 2017, with Sena Medal on 26th of January 2016, and with Vishisht Seva Medal on 26th of January 2009. In addition, he was also awarded commendancies once by the Chief of Army Staff on 15th of August 2008 and thrice by the Army Commanders on 15th of August 1994, 15th of August 2011 and 15th of August 2012. Later, he rose to the highest rank of Major General in the Department of Judge Advocate General and retired as a Judge Advocate General of Indian Army. Under his able leadership and guidance, MIT University is growing by leaps and bounds. His visionary approach in outreach activity gives a new way of unique thought process. And with this, we invite our Director, Sir, of MIT Law School for the vote of thanks. Please, sir.
Thank you, anchors. Professor Dr. V.C. Vivekanandan, sir, Honorable Vice Chancellor of Hidayatullah National Law University. Sir, I visited your university when my son was posted in Raipur as ADC to the governor, and I visited MIT University Chhattisgarh also, out of curiosity. And I was very happy to have visited your university, sir. I thank you very much, sir, for accepting our invitation at very short notice to grace the inauguration ceremony as chief guest. Thank you very much, sir. We are so grateful to you. We also thank our Honorable Pro-Chancellor, Lieutenant V.K. Sharma, Ati Vishisht Seva Medal, our Honorable Vice Chancellor, Professor Dr. R.S. Tomar, for guiding us every minute to minute to hold this event in a better manner. We also thank Professor Dr. MP Kaushik for guiding us to hold this event in a better manner. We also thank all the faculty members and the team, Moot Court Committee, who have taken great pains to organize this event. I especially want to thank the moot court coordinators, Professor Dr. Renu Goyal, Dr. Manshi Trivedi, and Subhangi, Miss Subhangi. They were the three coordinators, and of course, Dr. Saroj, who has been helping us in organizing this event. And the moot court committee members, Sehwaz Khan, M.A. Sathe, Sri Prachi, Anaya Sane, Palvi Rajapati, Nandini Khandelwal, Sohail Khan, Shreyang Tombar, Devang Singh Tombar, Kanishk Anand, Riya Garg, Samarth Trivedi, Sreyangan Swami, Shreya Pandey, Sushant Singh, Anand Raj, Parth Kumar, Sam Sundar, Vijay Gupta, Anushka Bansal, and Monica Chaudhary. Thank you very much. We organized this advocacy competition, trial advocacy competition, because we wanted to give knowledge to the student how actually the trial functions, how trial court functions. In a trial court, there are three, as you know, there are two parties, prosecution and the defense. They both know what is the truth in the case. Judge is the only one who doesn't know what is the truth. At both sides, they try to advance their arguments in favor and in their favor. And judge goes which side can pull it better. And advocates get the benefit, whether just go this side or that side. Justice delivery system, as you know, is a complex system where, every day various witnesses are examined, and so many things happens in the whether witnesses are planted, not planted. As you've seen that Bombay Blast case, trial court convicted all of them, given death sentence also, life imprisonment. But High Court shut down that there is no prosecution has not been able to prove the case beyond reasonable doubt. And they filed appeal in Supreme Court has stayed. Judgment of Supreme Court is right, not because Supreme Court is correct. Judgment of Supreme Court is right because that is a court of ultimate consumption. If there is another court beyond Supreme Court, they may even turn down Supreme Court judgment also. So this is how you see law functions. That's why I say is a complex justice delivery system is a complex sort of affair where everything depends on witnesses. Witnesses are sometimes planted, sometimes eyewitnesses are there, sometimes they are circumstantial evidence only. So we thought to give all the students a experience of trial advocacy. Moot court competition, there are two sides and they advance their argument. Witnesses are not examined. But in trial, the student must know how to examine witnesses, how to carry out examination, how to carry out cross-examination, how re-examination, how the court asks questions. All these things are interrelated. So to give the students an opportunity how a trial function, we organize this thing. I welcome all the participating team, 30 teams who will be participating and who have registered from all over the country, and very good institutions, from very good institutions. And in the end, I thank everyone, especially the participating team, and I'm sure they'll put in their best. Participation is more important than winning. Winning to some people win, others may not win. I just said, lion is the king of jungle, but he succeeds in hunting only 35% cases. 65% cases he fails. but he's still a lion. He's the king of the jungle. So I wish you all the very best. I'm sure you'll do very well. And next time also you will come and participate. Thank you very much.
Thank you very much, General Rajendra. And I once again thank Dr. V.C. Vivekanandan, who spared a very valuable time and come and address us and give us very good inputs. And I wish this all the very best. And I think we can now close this meeting. Thank you.
Thank you, sir.
Thank you.
Thank you very much, Professor Vivekanand for getting online and addressing us. Thank you very much. Thanks a lot.
Thank you. Thank you very much.
Thank you, sir.
Thank you.
Thank you, sir. Thank you.
Thank you.
Yeah, please close the meeting.
Thank you, sir.